Understanding labor relations and collective bargaining. Workers and employers have different outlooks to the concept of labor relations and the collective bargaining process. Before we explore at the beliefs and actions involved in labor relations, it's vital to understand the rules that regulate the labor management relationship, what unions are, and how employees unionize. We can analyze these real issues by learning about the rules that govern labor management relations as well as why employees join unions. What is the definition of union in the context of labor relations and collective bargaining? Union is an organization of workers acting collectively, seeking to protect and promote their mutual interests through collective bargaining. Workers join labor unions for a variety of purposes: a hostile relationship between employees and management that need the protection of a union, groupthink, a family history of union membership, a legislative obligation, or even encouragement for management due to a harmonious relationship might all create conditions. Authors have questioned many public employees' comparatively substantial benefit packages as compared to private sector employees. Much of the recent criticism of unions has been leveled at public sector unions who represent federal, state, city, and university and public school employees, including teachers. Many people regard public sector unions largely accountable for state and city budget problems. Benefits have been reduced for many private sector employees, or they have been compelled to contribute more to the cost of benefits. As a result, efforts have been made to reduce public sector pay and benefits, as well as to limit collective bargaining rights. Employees in the public sector are one of the organized labor's final bastions of power. Every other field of work has seen a drop in union membership, diminishing its influence and visibility. Union members characteristically receive higher wages and better benefits than non-union workers. Unions also have contract terms that give workers greater job security and influence over work rules. Union security arrangements may require membership for workers. The two most significant variables are the laws that regulate unions and the power that they wield. The methods of contract negotiation and management may also be relatively different. The decline in union membership, the development of union-employer relations, and the strengthening of public sector unions are all hot-button issues currently present. The question is, why do employees join unions in the first place? What will be the long-term benefits? As seen in this chart, the percentage of employees represented by a union varies by industry. Government and transportation workers are the most likely to be affected. Collective bargaining is how working people gain a voice at work and the power to shape their working lives. Joining a union simply means that you and your co-workers have a role, since you collectively negotiate essential aspects of job circumstances. This might include gaining salary increases, improved access to health care, more job safety, and more acceptable and regular hours. The union also works with management to design a method for solving conflicts that the employees and their managers are unable to resolve individually through collective bargaining agreements. Once a collective bargaining agreement is signed, union officials collaborate with employees and management to ensure that the rights and duties outlined in the agreement are met. Greater job security. Unions provide its members a sense of independence from management's authority to employ, promote, or dismiss at will. The collective bargaining contract will include norms that apply to all members, resulting in more fair and uniform treatment. Unions often bargain for the processes that will be followed in the case of a layoff, which usually benefits employees with seniority. Influence over work rules. Where there is a union, workers may help set their working conditions and have an effective route through which to challenge situations they think are unfair. Grievance processes provide workers with a formal mechanism and aid in contesting unjust workplace behavior. Grievance procedures give workers a formal process and assistance in protesting unfair treatment in the workplace. Compulsory membership. Many labor agreements include what are known as union security arrangements. Union security arrangements are the labor contract provisions designed to attract and retain dues-paying union members. Here are the many forms of union security arrangements, as well as certain unique stipulations within the area of union security arrangements. When one considers the importance of security arrangements to unions in terms of numbers and guaranteed income, it is no surprise that such emphasis is placed on getting the finest union security arrangement possible. These arrangements range from mandatory union membership to allowing employees to choose whether or not to join the union. The union shop. Any non-union workers must become dues-paying members within a prescribed period of time. The agency shop, a union security arrangement whereby employees must pay union dues to the certified bargaining unit even if they choose not to join the union. And the right to work shop. Right to work laws prohibit union membership as a condition of employment. This map illustrates the states with right-to-work laws that guarantee employees the right to choose whether to join a union or not. In 24 states, right-to-work laws ban agreements that force employees to join a union as a condition of their employment. Employees in right-to-work states have the freedom to choose whether or not to contribute financially to the union. These states are frequently targeted by unions seeking to amend the legislation to create a more favorable status for unions.
Laws that created the legal framework for unions. Two major laws provide the rights and responsibilities for employee unions and employers: the National Labor Relations Act or Wagner Act and the Labor Management Relations Act or the Taft-Hartley Act. Rather than present the detailed history and development of labor law, our discussion will focus on these two important laws that shape much of the labor relations process. We'll then briefly summarize other laws that have helped shape labor management activities. The Wagner Act. It is known as the National Labor Relations Act of 1935. This act gave the employees the right to form and job unions and to engage in collective bargaining. In terms of labor relations, the Wagner Act especially requires employers to bargain in good faith over mandatory bargaining issue wages, hours, and terms and conditions of employment. The Wagner Act is cited as shifting the balance of power to favor unions for the first time in U.S. labor history. This was achieved in part through establishment of the NLRB or the National Labor Relations Board. The NLRB has primary responsibility for conducting union representation elections. Was given the responsibility for determining appropriate bargaining units, conducting elections to determine union representation, and preventing or correcting employer actions that can lead to unfair labor practice charges. Unfair labor practice. is an employer or employee actions prohibited by Wagner Act, Taft-Hartley Act, or other labor laws. Unfair labor practice are defined in Section 8 of the Act and include any employer tactics that interfere with, restrain, or coerce employees in the exercise of rights to join unions and to bargain collectively, dominate or interfere with the formation or administration of any labor organization, or discriminate against anyone because of union activity, discharge or otherwise discriminate against any employee because he or she filed or gave testimony under Act. And lastly, refuse to bargain collectively with the representatives chosen by the employees. The Wagner Act recognized unions as legitimate interest groups in American society, but the act met with strong opposition from many employers who often failed to live up to the requirements of the law. That's because employers recognized that the Wagner Act didn't protect them from unfair union labor practices, such as holding wildcat strikes. Wildcat strikes is an unauthorized and illegal strike that occurs during the terms of an existing contract. The belief that the balance of power had swung too far to labor's side led to passage of the Taft-Hartley Act, or the Labor Management Relations Act, in 1947. Taft-Hartley Act, or the Labor Management Relations Act. The major purpose of Labor Management Relations Act, or the Taft-Hartley Act, was to amend the Wagner Act by addressing employers' concerns in terms of specifying unfair union labor practices. Under Section 8B, the Taft-Hartley Act states that it is an unfair labor practices for unions to restrain or coerce employees in joining the union, or coerce the employer in selecting bargaining or grievance representatives, discriminate against an employee to whom union membership has been denied, or to cause an employer to discriminate against an employee, refuse to bargain collectively, engage in strikes and boycotts for purposes deemed illegal by the Act, charge excessive or discriminatory fees or dues under union shop contract. Lastly, obtain compensation for services not performed or not to be performed. The Taft-Hartley Act abolished the common practice of closed shop arrangements. In closed shops, a union totally controlled the source of labor, and all workers are required to join the union. Taft-Hartley Act also included provisions that prohibited secondary boycotts and gave the President of the United States the power to issue an 80-day cooling-off period when labor management disputes affect national security. Presidents are reluctant to interfere in labor disputes, and orders for cooling-off periods are very rare. Taft-Hartley also created the Federal Mediation and Conciliation Service, or FMCS, as an independent agency separate from the Department of Labor. The mission of the FMCS is to send a trained representative to assist in negotiations. Unions and EEO. Although much of the legal discussion so far in this section has focused especially on labor legislation, it's important to recognize that many of the laws discussed apply to labor organizations as well. The Equal Pay Act of 1963 requires that wages agreed to during collective bargaining must not be differentiated on the basis of sex. In labor relations settings, pay may differ only on the skill, responsibility, accountability, seniority, or working conditions. The Civil Rights Act of 1964 is as relevant to labor organizations as it is to management. Title VII requires unions to discontinue any discriminatory practices and engage in affirmative action activities if necessary. The Age Discrimination in Employment Act of 1967 means unions cannot mandate retirement of any of their members. Unions must make reasonable accommodations for people with disabilities and comply with the provisions of the Family and Medical Leave Act. Other laws affecting labor management relations. The Wagner Act and Taft-Hartley Act are the most important laws influencing labor management relationship in the United States, but many other laws regulates the relationship between organized labor and employers. Several important ones include the Railway Labor Act, the Landrum-Griffin Act, Executive Order 10988 and 11491, the Racketeer Influence and Organizations Act of 1970, and the Civil Service Reform Act of 1978. The Railway Labor Act of 1926. Although the act covers only the transportation industry, it was important because workers in these industries were guaranteed the rights to organize, bargain collectively with employers, and establish dispute settlement procedures in the event that no agreement was reached at the bargaining table. The Landrum-Griffin Act. The purpose of this act is to monitor internal union activity by making officials and those affiliated with unions accountable union funds, elections, and other business of the union. Executive Order 10988 and 11491. Presidential orders legalizing and defining rights required agency heads to bargain in good faith, defined unfair labor practices, and specified a code of conduct for labor organization in the public sector. Racketeer Influence and Corrupt Organizations Act of 1970. Law passed to eliminate any influence on unions by members of organized crime. RICO has been used to oust a number of labor officials alleged to have ties to organized crime. Civil Service Reform Act of 1978 established the Federal Labor Relations Authority or FLRA as an independent agency within the executive branch to carry out the major functions previously performed by the FLRA.
Unionizing employees. The process for employees who request certification of a union to represent their interests is called an organizing campaign. Union organizing process. Each of the steps in the process of organizing and certifying a union is clearly defined. Both the union management must respect the right of the other. In terms of preparation, the employers are really surprised when employees are preparing for an organizing campaign. There are usually a number of conditions that prompt workers to be receptive to an offer of assistance from a union. As employees who feel that management is uncaring, unresponsive, unfair, and disrespectful are just as likely to seek union representation as workers that are primarily concerned about pay and benefits. Preventing unions starts with developing a culture that encourages cooperation, communication, participation, and good relationship with workers. How can employers tell if an organizing campaign may be coming? And these are may notice activities such as increase in complaints or question about policies, employee gatherings with an unusual mix of people, former employees or strangers hanging out at entrances or parking lots to talk with employees, appearance of union literature in the workplace or parking lot, appearance of union advertisement on local media. Authorization card campaign. The process may begin with employee representatives requesting a union to visit the employees' organization and solicit members. The union itself might initiate the membership drive using methods as old as picket lines or as new as the latest social media to promote their benefit to workers. And before approaching the employer for recognition, the union must secure signed authorization card from at least 30% of the employees eligible to participate. Authorization card, a card signed by prospective union members indicating that they are interested in having a union election held at their worksite. Petition the NLRB. If enough authorization cards are submitted, then the union can approach the employer for recognition. At this point, the employer may choose to recognize the union voluntarily, but that rarely happens. When the union is refused recognition, It petitioned the NLRB who reviews the authorization card for validity. When the NLRB is satisfied that the authorization card and the petition for recognition are valid, a representation hearing is scheduled with the employer and employee representatives. Bargaining Unit, employee group represented by union. The NLRB election then scheduled Representation Certification or RC. Election to be held by secret ballot. It also requires the employer to submit a list of the names, addresses, and phone numbers of all employees who will be eligible to vote. This list is provided to the union so they may contact all eligible employees about the election. This one method to remember prohibited activities is by using the acronym TIPS. First is threaten. Cannot threaten to close or lay off employees if the union is certified by workers who support union or change their working condition. Second, interrogate. Cannot ask who signed authorization card or who support the union. Third, promise. Cannot offer pay benefits or changes in terms of employment or working condition if union is defeated. And lastly, spy. Cannot determine who is attending union meetings by attending meetings, watching parking lots or meeting site, writing down license plate numbers, take photos of attendees, or question employees about attendance or content of meetings. Certification. If majority vote is received, the NLRB certifies the union and recognizes it as the exclusive bargaining unit, whether the individual in the certified bargaining union voted for or against the union. Each worker is covered by the negotiated contract.
Collective bargaining. Objective and scope of collective bargaining. Contracts must be acceptable to management, union representatives, and union membership. There are 4 issues that mostly appear in all labor contracts. These are the wages, hours, terms and conditions of employment, grievance procedure which designed to permit the adjudications of complaints. Collective bargaining participants. Management is represented by senior management for industrial relations, corporate executives, and company lawyers. In small companies, the president typically represents the company. Union bargaining teams include an officer of the local union, local shop rewards, and representation from the international or national union. Government watches to ensure rules are followed. This flowchart illustrates the steps in the collective bargaining process. Collective bargaining process. Preparing to negotiate. Fact gathering includes internal information, for example, employee performance records over time, and external, that is the data on what similar organizations are doing in the economy. Goal setting. Management decides what it can expect from the negotiation. Strategy development. This includes assessing the other side's power and tactics. Negotiating at the bargaining table. Each side usually begins by publicly demanding more than they are willing to accept. More realistic assessments and compromises take place behind closed doors. After oral agreement, a written contract is submitted to the union for ratification. Failure to reach agreement. All the contract negotiations aim to achieve an agreement acceptable to all concerned parties. Sometimes that goal is not achieved. When negotiations reach a point that both parties are unwilling to negotiate any further, they are said to have reached an impasse. These events may be triggered by internal issues in the union, the desire to strike against the company's desire to lock out the union, or its knowledge that striking workers can be replaced. Strikes versus lockouts. There are 2 types of strikes: economic strike. An impasse that results from labor and management's inability to agree on the wages, hours, and terms and conditions of a new contract. It occurs when the 2 parties fail to reach a satisfactory agreement before the contract expires. When that deadline passes, the union leadership will typically instruct its members not to work and to leave their jobs. Organization may hire replacement workers and no disciplinary actions can be taken against workers who participate in economic strike activities. Wildcat strike takes place while a contract is in force and generally occurs when workers walk off the job because of something management has done. Wildcat strikes are unfair labor practices, and consequently, wildcat strikers can be severely disciplined or terminated. Blackout, a situation in labor management negotiations whereby management prevents union members from returning to work. Blackouts may also be intended to force workers to accept reduced wages or benefits as an alternative to losing their job. Another reason is to protect work facilities, machinery, and other employees at the worksite from disgruntled workers. Impasse resolution techniques. When labor and management in the private sector cannot reach a satisfactory agreement, they may need the assistance of an objective third party. This assistance comes in the form of conciliation and mediation, fact-finding, or interest arbitration. Conciliation and mediation, impasse resolution techniques using an impartial third party to help management and the union to resolve the conflict. Under conciliation, however, the third-party role is to keep negotiations going. In other words, these individuals a go-between, advocating a voluntary means through which both sides can continue negotiating. Mediation goes one step further. The mediator attempts to pull together the common ground that exists and make settlement recommendations for overcoming barriers between the two sides. A mediator's suggestions, however, are only advisory and not binding on either party. Ethical issues in HRM. Pressure tactics. Although unfair labor practices are prohibited and bargaining in good faith is required, both unions and employers manipulate circumstances to gain an advantage in the collective bargaining process. For example, when labor shortages exist or when inventories are in short supply, a threatened union strike could have serious financial consequences for the company. Timing of a contract's expirations also influences how motivated parties are to reach an agreement. For example, a Midwest farm equipment manufacturer found that contract negotiations always broke down in November and resulted in a short strike that coincided with deer hunting season. Any strike situation, management has the right to keep its doors open and to keep producing what it sells, whether that means using supervisory personnel in place of striking workers or bringing in replacements. Fact-finding, the technique whereby a neutral third party conducts a hearing to gather evidence and testimony from the parties regarding the differences between them. Similar to mediation, the fact-finder's recommendations are suggestions only. They too are not binding on either party. Interest arbitration. It involves a panel of 3 individuals, one neutral and one each from the union, and management that hears testimony from both sides. An impasse resolution technique used to settle contract negotiation disputes. Public sector impasse resolution techniques show notable differences. Decisions rendered through arbitration are binding on both parties. Arbitration takes 2 forms. Package selection or final offer arbitration means that the arbitrator selects either the union or management proposal in its entirety. And issue-by-issue selection allows the arbitrator to select from union or management proposal for each issue being negotiated. Contract administration involves providing the agreement information to all union members and managers, implementing the contract, interpreting the contract, and grievance resolution and monitoring activities during the contract period. Communicate contract provisions. All parties need to understand the terms of the agreement and any changes in contract language. News may travel fast in a small organization, but larger organizations with many layers of management may need an extensive communication plan. For example, HRM must make sure its payroll system is adjusted to the new rates as set in the contract. If both sides agree to something not in existence before, such as change in the leave policy, all must be informed of how it will work. It will be necessary to hold meetings to explain the new terms of the agreement. Implementing the contract. Successful implementations depends on consistent interpretation and implementations of the terms of the contract. Inconsistent applications of rules and procedures create uncertainty and suspicion. Most agreements include a clause defining management rights. Typically, management is guaranteed the right to allocate organizational resources in the most efficient manner, to create reasonable rules, to hire, promote, transfer, and discharge employees, to determine work methods and assign work, to create, eliminate, and classify jobs, to lay off employees when necessary, to close or relocate facilities with a 60-day notice, and to institute technological changes. Good HRM practices suggest that, whether the contract requires it or not, management would be wise to notify the union of major decisions that will influence its membership. Grievance process. Almost all collective bargaining agreements contain formal procedures for resolving disagreements involving contract interpretation and application. Grievance procedures. The first step almost always is the employee attempting to resolve the grievance with his or her immediate supervisor. If it cannot be resolved at this stage, the next step is to try to resolve it with the union steward and the supervisor. If that fails, individuals from the organization's industrial relations department and the chief union steward usually get involved. If the grievance still cannot be resolved, the complaint passes to the facilities manager, who typically discusses it with the union grievance committee, and successful efforts at this level move on to the organization's senior management and typically a representative from the national union. Finally, if those efforts are unsuccessful in resolving the grievance, the final step is for the complaint to go to arbitration, called grievance arbitration. This is a sample of grievance procedure. A typical grievance procedure begins at step 1 with an informal meeting with the employee and supervisor and may include a union steward or other local union representative. The grievance may be settled at any point, ending the process. If the problem is not resolved, it advances to the next step, involving specialists in grievance resolution from management or the union. Monitoring activities during the contract period. Both the company and union will gather data on how the contract impacts the company and workers, such as the effect on productivity, employee turnover, and the number of grievances and concerns. Monitoring activities covered by the contract, the company and union can assess the effectiveness of the current contract, recognize when problem areas or conflicts arose, and indicate what changes might need to be made in subsequent negotiations.
International labor relations. It is important to know that we're not making apple-to-apple comparison when we talk about the labor relation in other countries. Labor relation practices in the pursuit of the workforce unionized differ in every country. The union members in each country are calculated using indifferent criteria. They don't include all labor works. It may include labor associations that do not actively promote labor issues. A country with a high union density such as China may actually have the unions that are not very strong or too close to government influence to effectively advocate for worker members. The business approach to unionism, or emphasizing economic objectives, is uniquely American. In Europe, Latin America, and elsewhere, unions have often evolved out of class struggle, resulting in labor as political party. The basic difference in perspective sometimes makes it difficult for US expatriates to understand how the labor relation process works, because even the same term may have different meanings. In United States, collective bargaining implies negotiation between a labor union and management. In Sweden and Germany, it refers to negotiation between the employer's organization and a trade for entire industry. The word arbitration in United States usually refers to the settlement of individual contractual disputes, whereas in Australia, arbitration is part of the contract bargaining process. Each government has its own view of its role in the labor relations process. The role is reflected in the types and nature of the regulations in force. The US government generally takes a hands-off toward intervention in labor management matters. Australian government, to which labor movement has strong ties, is inclined to be more involved. Thus, not only the Multinational Corporate Industrial Relations Office be familiar with the separate laws of each country. It also must be familiar with the environment in which those statutes are implemented. China's rise as an industrial power has facilitated the population shift to larger cities as demand for factory workers has increased. Union membership in China has climbed to over 200 million, 32 doubling membership since 2000. All China Federations of Trade Union is the only recognized union federation in China and operates much like the AFL-CIO, representing dozens of trade and industrial unions. ACFTC is the largest union federation in the world. It sponsors legislation supporting workers' rights and works to unionize foreign-owned companies such as Walmart, McDonald's, and Dell. The role of union in China is quite different from many Western unions. The role of ACFTC is to be proactive in preventing labor disputes and develop harmonious industrial relations. ACFTU primarily acts to stabilize labor relations and as a liaison with the government to prevent work disruptions. Few workers file complaints with the union and many views the union as more sympathetic to the employer and government than the member workers. This distrust has led to increased worker strikes and formation of unofficial independent trade unions. In 2011, over 2,000 workers at a South Korean-owned LG factory went on strike after year-end bonuses were cut. The number of strikes has doubled since 2006, creating a troubling trend that concerns the government and employers. Understanding international labor relations is vital to an organization's strategic planning. Unions affect wage level, which in turn affect competitiveness in both labor and product markets. Unions and labor laws may limit employment level flexibility through security clauses. Different perspective toward labor relations. The organization must assess whether the labor relation function should be controlled globally from the parent country or whether it could be more advantageous for each host country to administer its own operation. Decisions reflects the relationship of the product market at home to the overseas product market. When domestic sales are larger than those overseas, the organization is more likely to regard the Foreign Office as an extension of domestic operations. American firms have been more inclined to keep labor relations centrally located at corporate headquarters. European countries have small home markets with comparatively larger international operations. Thus, they are more inclined to adopt to host country standards and have the labor relation function decentralized. Another divergence among multinational companies in their labor relation is the national attitude toward unions. American multinational corporation views unions negatively at home and try to avoid workforce unionization. Europeans have had greater experience with unions, are accustomed to a larger proportion of workforce being unionized, and are more accepting of the unionization of their own workers. In Japan, as in other parts of Asia, unions are often closely identified with an organization. The European Union. The European Union brings together a dozen or more individual labor relation systems. It is important to understand the dynamics of what will necessarily be a dramatically changing labor environment. Due to the challenges that unions in Europe have encountered, trade unions have seen declines in membership. European countries have been hit hard by a debt crisis caused by recession, real estate market collapse, years of borrowing money for expansion and generous benefits for public and employee citizens. As some countries in Europe struggles to pay their debts, they have been forced to reduce spending and make cuts in benefits that workers and citizens expect. This made the public employees to go on strike to protest that causes to stop services.